Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. You know, the fallout from New York Pistol and Rifle Association v. Bruen continues. We have seen case after case after case, which has been revisited and ruled differently upon now that we have the correct test for how to assess the credibility and constitutionality of gun control legislation moving forward. However, we're beginning to see more and more desperation out of those on the gun-grabbing left as they scramble around trying to find historical analogs to support some of their gun control legislation. Well, the truth of the matter is that in some instances, those historical analogs are there. They just don't have the guts to talk about it. So today, we're going to talk about kind of a humorous story, one that's been brought to our attention. So let's spend a few minutes and talk about when the Supreme Court forces you to admit that gun control is racist. Okay, so the story we're talking about today is a story that was published last week on the website The Trace, and it is an article entitled "Bruen Takes Gun Law Back to a Time Before Domestic Violence." Now, this was all the outrage over the case of United States v. Rahimi, a case that we talked about and geeked out on in this video right here. For those of you who are not familiar with the case, that is where the Fifth Circuit overturned a conviction for a gentleman who was charged with being in unlawful possession of a firearm because he had current domestic violence allegations against him. And what the court ruled is that there was no historical precedent going back to the time of the adoption of the Second Amendment that demonstrated that these types of regulations were considered to be lawful at the time of the ratification of the Second Amendment. Now, that has a lot of people completely freaking out, and I will tell you that I've even talked to people in the pro-2A community that are a little concerned about perhaps an overreading of the Bruen opinion. Now, this has already gotten all of those on the gun control left attacking the Supreme Court, in particular Justice Thomas, as much as possible. In this article, a Pepperdine law professor was quoted as saying, "Typically, if you look back to history and you see a regulation, it is some indication that the government felt it had the right to regulate on that matter. Finding nothing, finding an absence, tells you nothing." So what this particular law professor believes is if you go back and you find a historical analog, that certainly justifies it. But the absence of it doesn't mean anything. How convenient for that to be the position. Now, of course, one of the problems when we're looking back at historical analogs is if we take a look at how this country has prosecuted domestic violence, and I will admit that we were a little late to the party on it. We really didn't see domestic violence protection orders and weapons surrender orders until the mid-1970s. So there is not a historical precedent for that type of thing. But this is what got everyone at the Trace all upset, because there is, in fact, a very rich history of restricting firearms from people that we believe to be dangerous. As the Trace put it, though, in the Rahimi case, the Justice Department had argued that the gun ban should be upheld because domestic abusers are dangerous persons. As historical analogs, the Department of Justice pointed to centuries-old laws that disarmed groups deemed dangerous at the time, including enslaved people, Native Americans, and British loyalists. The DOJ lawyers were adopting an argument that holds repugnant firearms restrictions of the past, though certainly no basis for discriminatory laws, are nonetheless instances of government having exercised a legitimate power, namely identifying dangerous actors and keeping them away from guns. And that is the dilemma that the gun-grabbing left finds themselves in, because if you want to argue that there is a rich and historical tradition of restricting firearms from people that society and the law deems as dangerous, you are correct. There is, in fact, that rich tradition. The only thing is, and this is what has to be admitted, because it is the inescapable truth, is that every single one of those laws for a couple of 100 years are based in one thing and one thing only, and that is racism. Don't believe me? Well, just take a look at some of these early American laws, some of which predate the Declaration of Independence and the ratification of the Constitution. Take, for example, these. 1640 Virginia, race-based total ban gun, that all such free mulattoes, Negroes, and Indians shall appear without arms. 1712 Virginia, race-based total gun ban, an act for preventing Negroes' insurrections. 1806 Louisiana, complete gun and self-defense ban for slaves. 1811 Louisiana, complete gun ban for slaves. 1819 South Carolina, master's permission required for gun possession by a slave. 1825 Florida, slave and free black homes searched for guns for confiscation. 1831 Delaware, free blacks were permitted to carry guns if the court approved them. 1831 Maryland, a race-based total gun ban. 1833 Georgia, a race-based total gun ban. 1840 Texas, a complete gun ban for slaves. 1844 North Carolina, race-based gun ban upheld because free blacks were not citizens. 1852 Mississippi, race-based ban on all guns. And let us not also forget the Militia Act of 1792 that specifically said that blacks could not join the militia and therefore would never be entitled to right to have a firearm. So yes, there is a rich history in this country of those that we perceive to be dangerous from being disallowed, forbidden from possessing firearms. The only thing that the gun-grabbing left has to do is admit what the evidence already shows, which is that gun control in its very inception is formulated on one thing and one thing only, and that is absolute racism. Now, I'm not suggesting for 1 second that any of these prohibited class of individuals were in fact dangerous, but I think we can all agree that that is how those state governments viewed them. Unfortunately, those beliefs were based on the color of a person's skin. What we're dealing with in the Rahimi case and other cases similar to that is actual empirical data that is based on a person's previous performances. So to all of the attorneys working for all the states that are feverishly working to disarm its citizens, and to all the attorneys working for the United States Department of Justice, there is an argument. It's sitting there right in front of your face. All you need to do is admit what we already know, and that is that gun control in its very formation is racist in nature. Listen, you may have more questions about this case or anything else related to what's left of our Second Amendment rights. If you do, you should know by now how to contact us. In the meantime, please remember that part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.